So we'll continue on since we went over a little bit. That's okay. Dorothy Ripka, many of you know. I think she, for our firm, holds the record for the most state licensures around: Ohio, Illinois, Missouri, Kentucky, and Texas. So Dorothy is a lead litigator with us, is in the Cincinnati office, and will be talking to you today about evidence, how to get it in, keep it out, and why it matters. Dorothy.
Good morning. Thank you all so much for being here. My topic is not as fun and exciting as Facebook and Twitter, but it certainly is tied very closely, as Raul mentioned. Before I get started into the presentation, I wanted to talk a little bit about why I brought up a stack of books with me and give you some general principles about evidence that I found to be true in my practice. I'm pretty much always the person with the biggest bag at court. It's guaranteed, because I bring my whole file, and I never am afraid to bring resources. There are a lot of times. I had a recent hearing in Kentucky, contesting the opportunity to fight this matter in North Carolina versus Kentucky, and the attorney said to the judge, "Well, I had that UCCJEA printed out here earlier. I don't have a copy of it." He's got the burden to the court to prove the law that's applicable, and he didn't bring a copy of the law. And that's really the issue that I see with evidence, and the reason why I recommend that you have resources available to you. And I've been practicing for almost 17 years exclusively in this area. I feel very old saying that. And this is actually my 15th one of these CLEs that I've both attended and presented at. And I was considering that as I was preparing my presentation today, and it dawned on me the fact that I really have been doing the same thing throughout this process, and that is each time I go through and prepare for trial, I do it as if I've never done it before, which doesn't make sense if you don't listen to why I say that. So here's my general principles. I begin my trial preparation the day I meet with my client for the first time. And how can you do that, and why would you want to? Because the information you begin collecting at that first consultation meeting is the surface of the trial. You're beginning to lay that foundation, and you're laying the broad base of, I call it the brick wall of your case. So essentially, you're beginning to learn what witnesses may be relevant. You're beginning to learn what kind of evidence may be relevant. And when I started practicing law, I definitely had a better memory than I do now. I had better eyesight too. So I feel like the only way to protect yourself and to protect your client through that process is to start memorializing those insights and those thoughts, and that give the opportunity to continue to build on that versus trying to create that, that story right before you go to a trial. So again, you're considering your witnesses, you're considering your exhibits, you're considering what you might even need to get your exhibits into evidence. I can tell you, when I tried a case in Dallas, Texas about 8 years ago, and my client was on disability from Social Security due to stage 4 liver cancer. The opposing party actually, despite seeing the medical records, refused to accept his Social Security documents he received. So I had to subpoena them directly from the federal government. It took 9 weeks to get them, and they came with blue ribbon along with a golden seal that could not be broken to authenticate them. And if I hadn't thought about that more than 9 weeks in advance of trial, I probably wouldn't have gotten his child support terminated. So that's the kind of insight and planning that's really required when you intend to try cases effectively. The other thing that I learned from an attorney that I worked for when I first started practicing was about starting your trial notebook early. Most of us take depositions in cases that we plan to try. And if you begin your trial notebook at the deposition phase, so that when you show them Exhibit 1, which is a statement of income and expenses, and you show them Exhibit 2, which is their statement of property, then you have consistent answers when you show them Exhibit 1 at trial, and you show them Exhibit 2 at trial. It's very effective when you go to impeach a witness, and you don't have to clarify for the court, well, that was Exhibit 1 in the deposition, but now it's Exhibit 10 here in trial. So that's a very effective and insightful way to utilize tactics that get your point across to the court. It's also effective for your clients to have that continuity so that they're familiar with the exhibits and they're prepared. The other thing is starting a trial folder, and a trial folder is the part of the trial notebook that you create for just yourself. What I do with that is, again, I might, for instance, I'll show you a book that I like a lot called the Lawyer's Business Valuation Handbook by Shannon Pratt, who's pretty much the expert in that area. And if I know I have a particularly complicated business valuation or perhaps a very skilled expert on the other side, I will go in and pull some of the sample questioning that's in here. I will pull some of the elements because I'm not a business expert. I actually always say I'm smart enough to know that I need an expert in that area. So from that perspective, pulling from these resources, start creating your backup. So you pull through and you make a photocopy, start putting that in the front of your trial book. You have the elements of your case, make a photocopy of that, put that in your trial book. And I say all of that. You can, of course, do it virtually, which is what I would encourage most of you to do if you're starting to, like me, rely upon those computers and when you're trying a case. But it's still a little hard for me, so I imagine it is for all of you as well. The next thing I think is really important is actually planning out your trial. I have an outline that I provide my clients at least a week in advance of trial that is, I call it examinations, outlines. Excuse me, examinations and outlines. And what that does is it actually tells them the whole day. It says, here's what happens first. We meet at the courthouse. We have a conference with the judge. There's an opening statement. There's another opening statement. Here are the witnesses. Here's what you can expect each witness to do. And of course, I'm creating this for myself, but I'm also creating it for my client so that they have comfort in the process. Because you can't expect a witness or a client who's not prepared to effectively get in the evidence that you're planning to present in your case. We all know what we say in court is not evidence. The only thing we can create as evidence is the testimony we elicit or the documents we're able to have admitted. So you being really prepared is a great component, but it's certainly not the most important component. Having a total plan is really key. Another part is I create an evidence tree, and this came in extremely handy recently when I tried a case that involved a motion to compel, 4 contempts, a motion to terminate joint custody, a motion to modify parenting time, and a motion to decrease child support. Right? So what evidence do I need? What are my legal standards? How am I going to get those in? What witnesses will I be utilizing to get those in? It was overwhelming to me at the time. So I created this evidence tree, which helped me break down each cause of action independently and break down what witnesses I needed to call, break down what evidence I needed to get in, and how I would get that evidence in. And I think that that's a really helpful tip to use, especially in a complex matter when you're trying multiple motions at one time. Part of that is also determining how to get that evidence in. So sometimes, and I'll talk about this in more detail after I go through my little summary here, but essentially how you're going to get it in is not just what are the elements of it, what's the foundation you need to lay, but also who is getting it in and what's the most effective witness to get it in. Also, it's important that your evidence be used to create a theme for your case, and that you do that in a very linear and clear manner, and asking very clear questions. I'm not suggesting anyone write out all their questions. I think generally that's a good way to not be successful in trial, is to have a script, because you're not utilizing your legal brain that you've been honing all these years. You're not using that brain to listen at trial. But on the other hand, I do think it's very key you have a roadmap laid out for how to try your case. Last point is knowing who you're presenting this evidence to. Raul talked a little bit about this, and I apologize, our topics are well placed because they do overlap quite a bit. It's important to know what the judge likes. It's important to know how they handle their hearings. He referenced court reporters. Where I practice as a matter, I don't have a court reporter. Everything's electronically recorded. So if I came into court without marked evidence, that would be wasting my trial time. And it's important to know, how does the court conduct themselves? How do they expect you to conduct yourselves? Do they expect opening statements? Do they expect written closing arguments? And knowing that helps you be prepared, and of course helps your clients and witnesses be prepared as well. And almost to my presentation. My last point is, don't be afraid to do a post-op, meaning at the end of trial, don't be afraid to think about what went well and what went poorly. I had never thought of doing that until I tried a case in front of Judge Burton back in probably 2003. And Judge Burton called me and asked me if I'd come into his office. And he proceeded to give me a lot of important information about what I had done well at trial and where I could have done better. The good news is it was a good result for my client, so I didn't feel too badly about the mistakes I made. But at the same time, they've lived with me, and they've been part of the reason I feel very passionately about this process and very passionately about being prepared. And he recommended to me a book that I ironically forgot today, but I always bring to trial with me, which is Evidentiary Foundations. And that is where you can always look to if you are confused about or trying to make sure you have all the elements in to lay foundation to admit evidence. There are a lot of really good examples in there of how to do it. And I have found in my practice that I've never had a judge or a colleague say no when I've asked them for feedback, when I've asked them for an opportunity to discuss a strategy for trial, something that could have gone better. So I think using your resources is such a key piece of being a good trial attorney and getting evidence in. Okay. So I started off with a joke, which basically says that the judge says to the lawyer, I'm glad you know a little bit about law. That's helpful. And I think that that's kind of the point, is that the court's not looking for you to know everything about law. They're looking for you to educate them about the facts of your case. And the way you do that is by, of course, admitting evidence. In order to admit evidence, the first component of that is it must be relevant, meaning does it pertain to the time, people, and event in contention. As I said, I've only practiced divorce law as a professional, and so when I'm contexting all this in primarily the divorce context, of course. So thinking about when you're trying a divorce case, what are the things that are relevant to this case, and what component are you trying to prove by admitting this evidence? Second piece is there proper foundation for this evidence? Has the competency and authenticity of this evidence been established? This isn't something you should be thinking about when you draw an objection. This is something you should be thinking about when you're putting together your case in advance of the trial, well in advance of the trial. Additionally, to admit evidence, the evidence must be in proper form, and essentially, is the question being correctly phrased? Does the best evidence rule relate? No exceptions can apply to this admission, meaning are there privileges that exist, attorney-client privilege, marital privilege. Of course, marital privilege is waived in an inter-family proceeding, but certainly could apply in other contexts with other witnesses. Are there any public policy exceptions, and of course, hearsay exceptions? And we'll go into those in more detail. The definition of relevance is that it's evidence that is relevant if it has any tendency to make the existence of a material fact more probable or less probable than it would be without the evidence. So obviously, generally only relevant evidence is admissible in legal proceedings, but there are times when that's certainly not true. Evidence that is not necessarily relevant may be admitted at the judge's discretion, evidence that is relevant may still not be admitted by the judge at his discretion if the probative value is not outweighing the harm that could be done by introducing it, the danger of that evidence coming in. The one you hear most commonly is unfair prejudice to the party. You'll see examples of that where people are attempting to bring in something that is so inflammatory, is only on just the edge of relevance, and is just so inflammatory that the probative value certainly does not outweigh the harm of bringing in that kind of evidence. And you certainly see that in divorce cases frequently. Efforts to comply with the evidentiary rules, there may come a time when the court is refusing to admit relevant evidence. And Raul referenced this. This is when you have to make your offer of proof. It's required in order to preserve this issue for appeal, that you can demonstrate that the evidence was relevant and should have been admissible, and therefore it was improperly excluded. Your offer of proof requires that you establish, one, that the evidence was demonstrated to the trial court that it was relevant when the testimony was offered, two, that it was specific, and three, that it's definite, meaning you can't just say, well, Judge, I think if you would have heard this witness, it would have been relevant, so I'm going to offer proof here that should have happened. That's insufficient. You have to actually request to make that offer of proof, and you have to engage in the testimony of the witness, offer the evidence in that you would have offered had the objection not been, in your opinion, wrongfully sustained. So you have to lay the record as if there was an opportunity to do that without the objection being granted. So that sometimes is a hard process. I know myself, I often feel rushed to go through the offer of proof because the judge has either left the room, they're not listening, or they say they're not listening, so they stay in the room. But I feel like the offer of proof is something that is underestimated for importance, and I would encourage you to think about, if you have a piece of evidence that may be excluded, I would think about how you would make that offer of proof. I had that recently with an expert who offered rebuttal testimony, and the court indicated that because he hadn't provided a report on rebuttal testimony, even though I disclosed him as a rebuttal expert, he wasn't going to entertain the rebuttal evidence. And so I went ahead and just went through, and I offered the testimony, and ultimately, again, thankfully it didn't matter. It wasn't an issue that was appealed because we were successful on the issue that he was testifying regarding. However, I think it's really important you think about how that offer of proof plays in and how you would handle that if you are challenged. And remember, it needs to really be in a question and answer format, not just an argument to the court. Just a reminder, settlement offers are not able to be introduced into evidence. They're properly excludable. Settlement offers, even concessions made, meaning admissions of facts that are made in the process of settlement. One thing I didn't include, but I think we all know, is mediation is properly excludable as well. So don't try to bring in any information that happened during the mediation process. Habit evidence is an interesting point, I think, as someone who only practices civil domestic relations law. It took me a little while to understand the difference between habit and character evidence, because character evidence, for those of you who practice across broad practice groups, you probably understand this better than those of us who focus in one area, because character evidence really isn't relevant in civil proceedings. It's really habit evidence that we're attempting to get in. So it's important you understand that distinction. Habit evidence is evidence that a person or organization always or automatically acts in a certain way, and that would be admissible to show conformity of that behavior on a specific occasion. So essentially, as I said, it should be distinguished from the inadmissible character evidence by these three factors: specificity. So the more specific the behavior, the more likely it is a habit. The regularity, the more often the behavior is occurring, the more likely it's a habit. And then the automatic component, which is just showing that that's a manifestation of the behavior, so again, habit. You would need a witness who can testify also that they have familiarity. They need to have known the person that they're talking about the habit evidence, and they need to be able to testify that this is a specific pattern of behavior they're familiar with, and that they've witnessed this a number of times, and in their opinion, it's a habit. And that evidence can be, I think, extremely helpful in custody cases, as Raul was referencing when you're talking about how people handle themselves around their children, how people handle themselves in social scenarios. Habit evidence is part of where you can have evidence coming in on the Facebook and social media type components as well. Again, Missouri has really limited the usage of habit evidence because of the argument I was telling you earlier about where the probative value is being outweighed by the harm that's done, because generally we're using it to prove that someone's has some bad acts that they are that they have been engaged in. Excuse me. In order to get evidence in, obviously you have to lay that proper foundation. So in general, the proponent must establish a proper foundation, which consists of establishing that the witness is competent and that they can authenticate the evidence. A party that is attempting to introduce or admit an item of evidence is laying the foundation for the admission before formally offering this item into evidence. For example, if I'm attempting to introduce a business records, I must include in the foundation an identification of the records. I must include the records' mode of preparation. It must be made in the regular course of business, and is made at or near the time of the act or condition that's being recorded. The foundation to admit business records was usually laid through testimony of a witness, properly identified as a custodian. I recall in my early practice taking quite a few custodian of records depositions that I'm sure people don't do that, have to do that anymore, because practically we now all pretty much rely upon a business records affidavit as an opportunity to have that put in place. They can also be admitted under statute here by serving the records with the attesting affidavit of the party's custodian at least 7 days prior to trial. Medical records also by statute may be admitted as business records under Missouri law. And police reports have been extrapolated to also be applicable under that same statute. The statutory references there are 490, 680, and then 490, 692. However, it's very important to remember that just because something is admissible under the business records exception, even with the proper foundation being laid, you're still subject to objection of the content. So in offering a police report, even though it may be admissible as a business records, that doesn't get over what may be conclusions or hearsay that are contained within there. One of the things as a practice tip I always recommend is we may discuss the fact that there's an agreement as to the admissible nature of a record from an authentication perspective. Yes, I agree, the business records authenticate this so I'll agree to its admissibility. But you have to make sure that there's also an agreement that it will be admitted into evidence without objection. Because again, that authentication that you've laid the foundation for is one component. You still have to admit it into evidence over other objections that may be properly taken. Most likely, though, the foundation for evidence will be witness testimony. So, for example, if we have a photograph that Raul referenced, or maybe it was Scott, referenced of mom having a good time with the child in the background, the elements to lay that foundation are that the witness is familiar with what's in the picture, so the object or the person or the scene, that they can explain that familiarity through their testimony, that they recognize this person, and that they believe that the photograph is a fair, accurate representation of what occurred. I think that that's the most common way we get most evidence in, especially in the family court kind of process. when you're laying the foundation of evidence through a testimony of a witness, it's also important that when you're questioning the witness, that you make sure you use very clear language, because having prior knowledge about something doesn't necessarily give current knowledge about something. So if you indicate, did you previously have knowledge of this activity or of this person, you need to be very careful you're laying the time frame, because the time frame needs to match up with the evidence that you're attempting to put in place. I'm sorry, I get talking and forget to advance. I apologize. Making sure, though, with this that you're keeping it simple. It's important to use clear and concise questions that are short, and that if you have to have your witness know what the right response is. Essentially, if you're not preparing your witness to understand what the components of the evidence need to be, you may not get the answer you're expecting. So if you ask someone, isn't it true that you recognize this scene or this person, and they're not prepared to answer, they may give a less than definitive answer, which may affect your ability to get the evidence in place. Again, being prepared is so key with your client and your witnesses, not just for yourself. I actually attempt to go as far as to explain to clients the components of the evidentiary direct, so that they understand why I'm asking them the questions I'm asking them and why it's important they definitively answer those questions. I see what I'm doing, sorry. And remember, once you've laid the foundation, you have to still move for the admission of that exhibit. It's not admitted into evidence merely because you have authenticated it and laid the foundation, but you have to remember how to admit that evidence. As Raul said it again, important to know your judge. One of the tips I would give in this area is when creating an exhibit list, which is certainly necessary for a trial of any length. I always create two columns, one being the introduced column and one being the admitted column. If you don't introduce evidence, you can't admit it, obviously. And if you don't admit it, then while you introduced it, it won't be something the court will be considering. So it's very important that you keep track of that for yourself. Some judges are nicer about that than others as far as helping you make sure you've moved for admission of your exhibits, but ultimately it's extremely important that you are making sure you are responsible for that evidence. Okay, sorry. Okay, moving on to authentication. Real or physical evidence, writings or photographs that are required for authentication. So again, as I said, real evidence can be authenticated by the witness's testimony if he or she recognizes this, the evidence that being asserted, and that they have knowledge of the chain of possession. Sometimes we hear it called chain of custody, and that it's been unbroken. Writings can be authenticated in multiple ways. First is stipulation of the parties. One of the examples that Raul gave is stipulating, for instance, to Facebook records and saying, we agree there's been adultery, these items don't need to come in, or they've already been authenticated, we don't have to spend a lot of time on them because I stipulate. Admission is admission by the party whom the offer is, admission by the party against whom the writing is being offered against, that the writing is genuine. So for instance, I had recently a trial where my client received, he made a bad decision, and he wrote a letter that he shouldn't have written, and before, but he had his sister put it into her handwriting. Can't make this stuff up. So they produce it to the wife, and of course, sister's not there to testify, so should this come into evidence? Well, probably not, it's hearsay. My client says, well, yeah, I had her write it, I delivered it. I am familiar with that writing. Well, that's exactly here. It's an admission by him that he knows that that writing is authentic. And while it should have been properly excluded as hearsay, it couldn't be because he had knowledge of it. So he was able to admit it and therefore authenticate it. Eyewitness testimony, testimony by a party who saw it executed is another method. And then there's the ancient document rule, which is 20 years or older, that a document is deemed authenticated if in its regular face and found in a place where you'd expect for this document to be found. Objection, the prosecution is attempting to lead the witness. An objection is an on-the-record statement of opposition to the introduction of evidence or of the asking of a question. Make the objection is kind of the first point here. Make the objection. And what do I say, make the objection? I mean, it's not automatic. Evidence is generally not excluded unless an objection is made. I have occasionally had a judge or magistrate make an objection for someone, but that's really not proper. It does happen. So in other words, you have to make the objection for your record on appeal to be preserved and to have any opportunity to exclude that evidence from consideration by the judge. It certainly is required that you make a timely objection. You can't wait until we've moved on from the question and then attempt to object to it. And then as far as an answer being objectionable, that's something that happens very frequently, and I see people hesitate. You have to make an objection to the answer if it's objectionable, and you have to request that the court strike it. If you object and your objection is sustained, that's wonderful, but guess what? The answer's out there, and it's not been stricken from the record, so when the court goes to review this decision, maybe it's in 2 weeks, they can still review the answer. You haven't stricken it from the record, therefore it's still part of the record for decision and for record for appeal. So make sure you are not only objecting to the question, but potentially to the answer. Specificity of your objection is required. What that means is you must state a ground which you're basing that objection upon. If a party fails to make a specific objection, then it's considered a general objection. That general objection that is sustained, i.e. the evidence is not admitted, will be upheld on appeal if there are any grounds for the objection. However, if it's not sustained, which is usually what happens, and the evidence is admitted, this objection is not preserved unless the admission is constituted plain error. Plain error is that the evidence should have been inadmissible under any circumstances. In review of Missouri case law, I see that the appellate courts almost never reverse on plain error. So you cannot rely upon a general objection. Responding to objections is also key. And if an objection is sustained, then again, making the offer of proof to preserve that right on appeal. So the offer of proof relates not only to a document or a witness not being able to be admitted into evidence, but also potentially an objection being denied. So that offer of proof is, again, a statement as to why you believe that question or evidence was valid and potentially going through a question and answer if necessary on the objection. Remembering the burden is on the party who is objecting to the admission, so you must be sufficiently stating that grounds. While we don't want to think about this, we are making our record for appeal. And more importantly, you may be making your record for appeal when your client's going to have a different attorney pursuing that appeal. So it's very important that you are considering not only protecting your client, but you're protecting the record for yourself as well. Objections preserve this claim so that in the event there's any evidence allowed that should have been excluded, the court can consider that in the appeal. Sufficiently specific objections are being raised timely. That's the only way the court can act. And you must remember that the scope of the objection will not be broadened on appeal, nor can a different objection be applied other than the one that you raised. So if you object on a hearsay ground, that's it. Hearsay is what the court will consider on appeal. Again, it's good preparation for you with your exhibits and your witnesses to consider what are the potentially objectionable issues here? What are the potentially objectionable exhibits? How will I be prepared for this? What are my responses to potential objections? And again, when going through that evidence tree, I recommend to you that you think about, if I were on the other side, what would I object to? Why would this not be relevant, or why would this not have proper foundation? And I think you should think about responses to potential objections. I feel like a lot of times people are thrown off when the objection gets thrown up because they haven't considered the flip side of how to respond to an objection, and that's very important. And to that point, the motion in limine that Raul referenced is extremely important. A motion in limine can help you limit the issues that are before the court on specific evidentiary pieces. I don't think it's extremely common to use a motion in limine. Some jurisdictions that are more formal, like Texas, where Raul is from, when I practiced in Texas, I used motion in limines probably a third or a quarter of my cases. Now, where I practice in the Cincinnati area, it's almost exactly like practicing here in the metropolitan area of St. Louis. It's a very different, more laid-back approach. And so a motion in limine would not be something I would use, except maybe be 10% of my cases. You want to make sure you're using them in cases where it makes sense, especially if you have judges that are very strict on timelines for trial. Some judges give you 3 hours, and that's all you get. So if you don't think that you're going to have enough time for your trial, if you have to make evidentiary arguments like this, it's a very good time-saving method. And again, remembering, though, if you make the motion in limine and it's not granted, you are still required to renew those objections during the trial. You have the same issue of waiver if you fail to do that. So make sure you're making those objections at trial. If a question itself is not objectionable, but the answer is, remember, that's the same issue. You need to prepare your client for the objection, and how does your client respond? So if you draw an objection, and inevitably it happens to all of us, our client just keeps talking over the judge and keeps talking over the other attorney, you need to prepare them. If you see the other attorney stand up and you hear the word objection, you stop talking, and you wait for the judge to instruct you. For jurisdictions like mine, and I think most of this area as well, where you're relying upon a recording of a hearing, it's extremely important you do this as well. Because if they cannot take down what happens during this interplay of the objections and the responses, then potentially you have waiver issues as well on your evidence. So your client, it looks disrespectful to the court, but that's really not the biggest point. The biggest point is you don't have the ability to preserve your record if your client's talking over the top of you or the judge. So making sure your client is very prepared in that regard as well. Best evidence rule, not something I see come up too often, but in this day and age where everything's virtual and electronic, it's uncommon that someone makes the argument that they were requiring an original. An original with a copy is really sufficient, an appropriate copy. As you'll see, the statement of the rule is you're trying to prove the contents of a writing or film, recording, picture. The original must be produced or a satisfactory account of its absence. An original document can be any duplicate that accurately reproduces the document, i.e. photocopies. So it's very common that we may not have an original of something anymore, but we have a printed off, a digital copy. We've made a color copy for the court, those kinds of things. And again, as long as you have a reliable document that's something the court can look at. So this rule is only applicable when the writing is a legally operative document, deed, contract, written or recorded statement, and the writing is offered to prove an event, or the witness's sole knowledge of the fact comes, their testimony is based on that writing. It's not applicable, and copies may be used when the event or facts exist independently of the writing. So the example I gave here is birth or death certificates. We don't need the writing to prove those facts exist. The writing is of such minor importance that it's really collateral to the ultimate issue. So again, that's where photographs and things like that come in. They're certainly relevant evidence, but they're not the linchpin of the case. You must make sure that it's properly being authenticated and that there's no hearsay objection. Just because you overcome a best evidence objection doesn't make it admissible. I'm quite certain that there are absolutely no cooking of the books here. Reheating, however. And I think we've all probably heard an expert give a similar answer. So again, being sure, these are just kind of some points to remind you of you're addressing or objecting to identification, authentication, relevancy, best evidence, hearsay, and privilege. And I've put note under hearsay. And remembering, for hearsay purposes, that's one of the ones I always bring a cheat sheet to court. I have a printed cheat sheet that helps me remember what are the items that I want to object to, so I can properly form those objections in a quick, succinct manner, so the court can document my objection. So it's important that you consider having potentially a little cheat sheet for some of the more lengthy objections, like a hearsay. These are some reminders on the self-authenticating documents, ancient documents, newspapers, trade inscriptions, commercial paper, i.e. money, a seal, an acknowledgement, domestic foreign public records, certified public records, official publications, and certified business records. Something to think about on those is there some statutes, again, provide additional self-authenticating documents, as we talked about today with the police reports. You want to think about and make sure you research if there's additional self-authenticating documents. Raul started on this topic talking about the social media and just thinking about, so I'm going to keep it really brief, but just thinking about how would you get that evidence in and why is it relevant and how will I get the evidence. My joke here is to quote further from People's Exhibit A, your Twitter feed, @HoldUpGuy, I'm in the getaway vehicle with the money and the hostages. Where are you? So, careful what you say. This is a little bit of it's a download cheat sheet for you on Facebook. I do use this when I do my request for production. It does hopefully get you around any need to subpoena. It's actually extremely simple, and you basically going into settings, download a copy of your Facebook data, and then you archive it, and then you can produce it to the other side. This is something very commonly used in my jurisdiction. I would say it's probably in 75% of our requests for production. So if you're not seeing a lot of it here yet, you certainly will. Again, usually my clients are educating me on it because they know how to do it better than I do. And then this one is a very good example. So the chalkboard it says patent number and then some very complicated algorithms, and it says, so you see, Your Honor, it's obvious. And you see a very perplexed judge. And the judge is the only person you are trying to convince. The judge is the only person you are trying to have understand your position. And if the judge doesn't understand, you really don't have a good shot at getting your evidence in, or at least winning your case. I've got, as a shout out here to Scott Trout, I've got a vocational evaluation report that's extremely old, but for those of you who do vocational evaluations around here, I'm sure you know Tim Caver with England & Company. And the key thing about these is understanding how to present this to the court. These vocational evaluations are something that can be extremely key in explaining to the court why a spousal support maintenance claim is appropriate or why it's not, and what the amounts should be. And I'm going to go into a little bit more about how to lay the foundation for the expert, but I wanted to show you that having a report, having this evidence, because if you look at the way Tim puts this through, and I'm certain Scott was instrumental in that, was putting in all the elements of the statute. You are part of this process. You are hiring this expert and explaining to them what you need the court to be educated on. And too often in practice, I will see a report come across my desk from opposing counsel, and it's one page, and it has no reference to what the ultimate issues are that the court's looking at. Yes, the trier of fact is the one who will be making the determination, but we can give them a little help. And we can explain to them the relative earning capacities. We can explain to them the ages of the parties. We can explain to them the health of the parties. Often you'll see in vocational evaluation reports, I've talked to this lady, there's no issues. If she went back into the market, she could get a job making $35,000, whatever it is. And this is a very different analysis where there's actually a review of the components that the court would be looking at and giving examples that the court can rely upon. So one example here is a labor market survey that Mr. Caver did and relied upon in making his determination as to the employability of wife. And these labor market surveys, again, remembering if your client comes in and says, oh, I looked on monster.com, she can get a job, that's not coming in. That's hearsay. It might not be very reliable. It might be a little jaded as well, but it's definitely not coming in because it's hearsay. He doesn't have any ability to talk about employability of his wife, and certainly Monster.com is not the place for him to gain that knowledge. But an expert who's relying upon the kind of evidence that an expert should rely upon, which means it may or may not be hearsay, in a labor market survey, and one that potentially relies upon the government websites which provide the employment and the average wages. Those are really key things to hone in on. So my point of that exhibit is to think about not only how to get it in, which, like I said, we'll talk about in a moment, but more importantly, how to shape the evidence that you're presenting to the court. You hire someone to come in and be persuasive and to win your case for you and your client, and you need to make sure they understand what the evidence is that you're looking to have them admit. And again, I've never really found an expert who wasn't willing to work with me on understanding what the judge was looking for. And that's why it's a good thing to have people come in and testify as experts who are very familiar with the court system. I'm going to run through the business valuation stuff a little bit quickly. I know you'll be hearing from some experts later on business valuation, so I just want to mention the importance, though, of an accountant in your case. Pretrial strategy planning, short and long-term income planning, and valuations. Those are three pieces to consider hiring an accountant for. The pretrial strategy planning, I think, can be very important. It's one that I think I probably underutilize, as do most people. But it's something to think about how to get them involved in the case, whether it be to make offers of settlement, whether it be to assess even property division and tax impact on those property divisions. I mean, those are things that are very helpful for your clients, especially if they have complex assets that they may not understand or that you may not understand. I definitely use experts a lot on the short and long-term income planning. Tax impact is obviously something the court needs to consider when they're running an analysis of the property division as well as spousal support. So considering the hiring of that expert in that piece is very important. And then also valuations for business purposes. And then just real quickly, I'll run through the type of valuations. Again, hiring a good expert is very key here. What type of valuation do you need? Is it a fair value, which is hypothetical? Is it a fair market value, an investment value, a book value, or a liquidation value? Obviously, depending which valuation method is utilized, the value of the actual entity will come out very differently. And I can tell you, your expert understanding this is very key. I had tried a case 2 years ago where my expert put a value on my client's business interests of $285,000, and the other expert said $1.9 million. Why did that happen? The other expert did not understand what the court was really looking at. First off, he used fair value. Fair value is hypothetical, meaning he's not considering the fact that my client was a 50% owner. So there's some limitations there in being a 50% owner with his brother in a family business. And then the 1.9 actually enveloped the entire business, not just my client's portion. So he really didn't understand what he was presenting to the court. And the judge said in that decision, when he sided with my expert's value, you get what you pay for. And it's very important that you make sure your expert knows what you need them to do and how you can help them do it. I would definitely make sure that you talk to your expert in advance and you lay out, these are the pieces of evidence I want to get in, whether it's tax returns, whether it's profit and loss statements, things that you know that you need the expert to help you educate the court on and how to get them into evidence. Because if they did not review them or if they don't say they're familiar with them, you may have some evidentiary hoops to getting that information into evidence. Another piece that's important on your expert is researching your expert. Google actually really is very effective I think you should probably take it a step further, but start with Google. We had a recent expert that the opposing side was proffering as an expert to come in and educate the court and explain to the court why my client, who was disabled, could actually come in and earn a bunch of money now, and even though he was found to be completely disabled as a fireman and could barely walk. Regardless, this expert had actually lost his accreditation through the American Psychological Association and even though he billed himself as a PhD, he actually no longer had accreditation. And I'm quite certain opposing counsel didn't know that before they proffered this expert and put them on the stand. And if we hadn't done our research, that could have been a very costly mistake for our clients. So again, this is what I'm talking about with how to attack the evidence of the other side and knowing how to object and why you should be objecting to their witness or their evidentiary documents. I'm going to skip through the revenue rulings because I think, like I said, you guys have a lot more of that later, and I'm, as always, talking too much. I think we hit those issues. Okay, so let's talk a little bit more about witnesses. My eyesight's going, like I said. My glasses. Jacqueline could see at the outset that her cross-examination would need to get beyond the happy face. And he's just smiling back at her. And that's an issue if your party that you're cross-examining is smiling at you. You're not doing your job. So proper form to examine the witness. So prohibited in direct examination is leading questions, obviously. You can certainly do them during cross, and if you don't do them during cross, you're probably not doing effective cross. You can also lead on preliminary matters. You can also lead when the witness has difficulty due to handicap. I've actually never seen that. I've never seen that sustained, but I have read research that happens. Or when the witness is hostile. So you've seen on TV, permission to call this witness as a hostile witness, even though you're calling them on direct exam. Generally, my recommendation for that is actually to ask to call a hostile witness on cross. You can just request that you be permitted to take this as cross-examination, as this is an adverse witness, and I've never had a judge not allow that. So that would be my recommendation as a practice tip there. Proper form, again, prohibited questions are misleading, compound, or argumentative questions. I would recommend that each of you get a trial transcript from the last time you tried a case and mark up your own questions, because we can all do better. And I saw someone say the other day, my least favorite thing I do as a lawyer, read my own deposition transcripts. And it's true, because we all ask bad questions, and we all ask compound questions. And so, really honing that is a really key piece, I think, to improving your examination of a witness. Questions that assume facts not in evidence, conclusory questions, and questions that unduly harass the witness are also excluded or prohibited questions. Use of a writing in aid of oral testimony. It's very common. You'll see someone hand someone a document and say, "What's this say?" It's not really the way it's supposed to work. A witness is not supposed to read a written statement aloud in court. There are some times when it is permitted, such as refreshing recollection. So a witness may use any writing or tool, such as a photograph, even a smell, for the purpose of refreshing his or her recollection, and if they cannot accurately recall the facts or events. And this is providing that this writing or document or smell does not come into evidence, and that opposing counsel has the opportunity to review the document, use it in cross-examination, and have the opportunity to themselves put it into evidence. Past recollection recorded is another exception there, where a witness states that he or she cannot remember and his or her recollection was not refreshed by a writing. Therefore, the writing itself can be read into evidence, but only if there is firsthand knowledge at the time. The witness had personal firsthand knowledge when this writing was recorded, that it is recorded in writing at the witness's knowledge, and that it was made timely, meaning the time of the writing and the statement were close together, and that it's reliable. Then the witness can testify that it's a reliable writing. Testimonial privileges do permit the party to refuse to reveal or prohibit others from revealing certain confidential communications during judicial proceedings. As I said, though they remember that the husband and wife spousal immunity is not allowed in interfamily, obviously, or we'd have nothing to do in divorce court. This says privacy, why bother if you've done nothing wrong? And this is, to Raul's example, of being careful what you put on social media, because it can certainly come back as an exhibit at your trial. That's my advice always in initial consultations is if you don't mind telling the judge why you put it on there or answering questions about it in front of God and everyone, feel free. But my advice is to stop. And usually clients get it together. All of us are familiar with the attorney-client privilege. Obviously, those confidential communications between attorney and client made during the professional legal consultation are privileged from disclosure unless they're waived. And the privilege does not apply if there's to the physical evidence that's given, if there are pre-existing documents, if the attorney services were sought to aid or plan or in the commission of a crime, and to communications relating to a breach of duty between the parties, meaning the client and the attorney. Physician-patient privilege is another objection, meaning the patient holds this privilege against the disclosure of the confidential information. This really applies again in our cases. I have a motion to quash right now pending from a psychologist where I've attempted to subpoena wife's 17 years of counseling during their marriage, and the grounds are that I don't have any relevant pieces in my trial. And the component why we're subpoenaing it, because the parties don't have any minor children at this point, is there's an argument as to when she actually left the marriage, and we believe the counselor knows that information because we have some other evidence that says that she came back so she could get a little more money and fix her teeth and do a few other things before they separated. So in that case, I feel fairly confident we're going to win, but it's still difficult to breach that privilege when the patient is refusing to waive, and in that case, the patient's refusing to waive. As Raul mentioned, there is a privilege against self-incrimination. At least, the caution is always, if you start pleading the fifth on one thing, that does prohibit your ability to prove your case on other elements. So really consider, before you go into the Fifth Amendment with your client, whether or not it's appropriate to plead the fifth on an issue, and then you can't maybe prove up your case on your spousal support or on your custody case because you may be prohibited from introducing other evidence as a result of pleading the fifth during your case. Other privileges, again, clergy, accountant, and those have been recognized in federal court, and generally the courts are going to recognize not so much the clergy privilege. I didn't see any case law that has the clergy privilege, but there are some states that do recognize that. So again, being creative, if there's a lot of people do choose to do marital counseling through their church, so be creative. If there's something inflammatory in there, you may be successful in keeping that evidence out. Opinion testimony. All witnesses are competent and can testify. Personal knowledge of the matter is required, and the witness must take an oath or affirmation to, of course, tell the truth. Lay opinion is admissible if the opinion is rationally based on the witness's opinion and helpful. Expert opinion is admissible if the judge is convinced by a preponderance of the evidence that special knowledge is one needed on the issue, and that this witness is qualified as an expert. A witness must be qualified as an expert by reason of knowledge, skill, training, experience, or otherwise. Thus, the witness doesn't necessarily have to have formal academic training to be an expert. There are other components where someone could be an expert in dogs. They don't have to be necessarily a veterinarian. They could be a dog trainer. So those kinds of things are things also to think about who might be able to qualify as an expert. The opinion is made with reasonable certainty, and it is supported by proper factual basis. Impeachment and rehabilitation. So these pieces are really key because impeachment is proving that a witness is not credible. It is done generally by cross-examination when you're seeking to impeach this witness, or through their own testimony or through extrinsic evidence. A witness may be impeached. I generally find, obviously, an inconsistent prior statement where you have a deposition where the party gave testimony and said, I have no issues, I can certainly work full-time, I don't have any mental or physical or psychological issues at all. And then we come to trial, and suddenly there's all of these, long diagnosed issues that make them unable to work. And we impeach by asking them again. You ask the same question with the same wording, and you get a different answer. And then you have the opportunity to go through and impeach. Impeachment is done very frequently incorrectly. It's very important that when you impeach, you make sure you're asking that same question. You make sure you're asking them through foundation that they recall having their deposition taken, that they recall being asked that same question, that they recall they were under oath at that time, they recall they're under oath now, and that they gave a different answer at that time. And impeachment does require them looking at that, but you may or may not want them to read from the record at that point. It's important, though, that that's against refreshing recollection. You want to think about that, because sometimes refreshing recollection you don't use to necessarily impeach. You're using that to help your witness if they have forgotten a fact or they're maybe not giving totally consistent testimony. You may want to use refreshing recollection versus an impeachment type tactic with the deposition. Important to remember, you cannot preemptively bolster. So as a general rule, you can't offer evidence that supports the credibility of your witness before they have done anything to call their credibility into question. The only exception of that is a prior statement of identification of a witness. So the rehabilitation of a witness, which I think happens a lot in family court, is the witness's credibility has been attacked, and you can rehabilitate that through evidence of good reputation for truthfulness or explanation on redirect. Obviously, the most common way we rehabilitate our clients is through redirect, when we offer them an opportunity to explain why the yes or no answer they gave on cross-examination was not really the whole picture. And it gives them an opportunity to give a whole picture and gives them an opportunity to rehabilitate their credibility to the court. And I'm running out of time. Ways to impeach. So really quickly, bias, inconsistent statements, character, and capacity. Non-character evidence purposes, motive, intent, mistake, identity, and common plan or scheme. And we haven't even talked about hearsay, and we're in evidence here. So really important, this slide is actually one of the opportunities for cheat sheets to use, and I apologize, it's kind of small probably to read. But again, remembering what the hearsay exceptions are, as we've talked about, business records, admissions, dying declarations, spontaneous or excited utterance, present sense impression, that's a really good one to use, because a lot of times you're not trying to prove something for the truth of what was said, but rather that it was said. So you'll hear kids say, it happens a lot with kids' statements in court, and you'll hear a child say, "Oh no, Daddy was so mean to me and I don't want to go visit with him." Well, you're not admitting that statement for the proof that Daddy was mean. You're putting it in there to show that court that there's a reason that this little boy didn't want to go, because this was his perception. This is how he was feeling. It's not that it's true. It gives the court that perception. And again, that's probably on the borderline, but that is a really good opportunity to try to get hearsay in. Learn treatise and in declarations against interest. Those are pretty important ones, along with the prior inconsistent statements. So we talked a little bit about the experts earlier when we were talking about the reports. So again, considering how to challenge your expert, witness qualifications, assistance of the trier of fact, the reliability of their data and methods. That's the Daubert challenge. Again, Daubert challenge is a really great opportunity for a motion in limine, especially when you're dealing with someone that is really basing things more on scientific fact, so mental health evaluations, where there's really an opportunity to attack their methodology. And the key thing about attacking methodology is you have to know it, you have to understand it. Every professional entity like ours has standards of practice that they want their professionals to hold to. So the APA, which is American Psychological Association, has guidelines for practice. And I would recommend you take a look at those and see, are those being followed in the recommendations? And then find out, are the tests that they're doing, are they doing the Rorschaching plot? Probably not really that reliable in this day and age. Are they doing the MMPI too? That has a lot more reliability in the court. So thinking about what's being presented and if that's reliable in this particular field. And again, thinking about how to Daubert challenge is important. Just a reminder, again, when you're laying this out, how to do which experts do you need and why do you need them, and what's the evidence that you would want to put in with them and getting in their evaluations. And who do you need to subpoena, and how would you overcome any objections to your expert, and how would you challenge their expert. For custody purposes, the key to a GAL report or a custody evaluation is to assist the court from seeing what's a disgruntled spouse versus a legitimate concern, to, as I said earlier, analyze the custody factors. A good GAL report and a good custody evaluation type report should analyze custody factors and give the court some assistance on those pieces so that the court can consider those. It also will have the opportunity to flesh out all of the potential terms of parenting time, visitation, custody. You also can use it to disarm, so you can distinguish between what may or may not be special needs of the child, and then also distinguish the two positions. This is an opportunity to give the court in writing what's the position of the two parties. From a property and debt division, I wanted to get to this one. Again, thinking about what type of experts do you need and why. So property and debt valuation, whether you need a CPA, whether you need a forensic accountant, which obviously has a different strategy. The forensic accountant is coming in to serve a specific purpose in your case, whether it be tracing and a cash flow analysis, an income evaluation, and that person has a different role than maybe the company's CPA, who can give all the background, can lay all the foundation for the evidence you need to get in to establish income and valuations. Also, of course, we all use real estate appraisers, potentially auctioneers, and other kinds of specialty evaluators. Just a reminder about finding out how to know your expert is legitimate. Making sure that they have a good CV, making sure that you know how to attack the other party's CV, making sure everyone has been subpoenaed. And I've referenced a few of those professional associations I was referencing here earlier, just so you can think about how to see the accreditations, understanding the differences between the accreditations, and understanding the standards of care that apply when they are making these evaluations. Really big point in Missouri is judicial notice. Judicial notice is the recognition of a fact as true without requiring formal proof through presentation of evidence. One thing that I know as a matter of course I always did when I practiced here was asking the court to take judicial notice of the file. Just because something's in the court file does not make it evidence. So unless you have asked the court to take judicial notice and to consider the contents of the file as evidence in the trial, you have not put into place potentially your pleadings that you filed, statements of parties, affidavits, that if they haven't been admitted through some other means, they're not admitted just because they're in the court file. So while you're thinking about things to do, I always write judicial notice on the top of my trial outline, so I'll remember to ask the court to take that judicial notice, and as well as rule on any outstanding motions in limine. And this is, I think I will end here and just say, this is Judge Bill Kim, in quotes, motion denied. He was a comedian until the end. Thank you.